Honorable Court is now in session.
Good morning to the attorneys. I assume that everyone has already set their times and their restrictions. Then just a couple of preliminary matters. We will be conducting these proceedings as if we were in court. And I hasten to add this part that you are not required to stand. You can do this at your desk where you're at. However, if you so desire, you may stand to make your presentation. We will begin, as we begin, if there is anyone has any technical problems, please let us know immediately so we can get to those. If there's nothing further, then Madam Clerk, are there any preliminary matters on this case?
No, Your Honor.
Then will you please call this case for us, please?
Estate of Alie Newman Maples et al. Versus Park Grill LLC.
For the appellant.
Good morning, Your Honor.
Yes, sir.
My name is David Parton,
Mhm.
and I'm attorney for the estate of Alie Newman Maples. It's being brought by her daughter, who is the personal representative of the estate and the sole heir.
Okay. Mhm. Go right ahead. You may proceed.
Okay. This is an appeal from the Chancery Court from Sevier County. It involves interpretation of a lease agreement between the two parties. Ms. Maples entered into a 10-year lease agreement back around 2008 with Park Grill. She basically inherited this property that is being leased from her late son, who passed away. Park Grill had been a tenant there prior to the death of her son.
Mhm.
The original lease was for approximately $300 a month, which is far below market for anything a half a block from the Parkway in Gatlinburg and any decent habitable place. The caveat was the tenant it was a triple net lease. The tenant was required to maintain all insurance, pay all the real estate taxes, and maintain the property. The lease was drawn up by attorney Jerry McCarter, who's been the Gatlinburg City judge for at least 40 years. There's some controversy over who Mr. McCarter was representing. We know, I think they would have presented any other leases that Ms. Maples had that Mr. McCarter had drawn. It's undisputed that it was the tenant that went to attorney McCarter to get the lease. Mr. McCarter in his affidavit stated that he understood the property was to be used for a parking lot, although there was an improvement on the property. The lease did require the tenant to maintain liability insurance and also to maintain fire insurance on the premises. It further down in the lease, there was a sort of escape clause that said either party could terminate the lease if there was damage to the extent that it couldn't be repaired within 10 days using the insurance proceeds. Chancellor relied upon that statement to limit what the insurance funds could have been used for at all. He said they were not available for any repairs that could not have been made within 10 days. Back to the history a little bit. Said the property previously had been leased to Ms. Maples' son. The same tenant had used the property for a daycare center for the employees of the restaurants, and then later as a bakery. They had done, I think their affidavits say approximately $140,000 in repairs of this little cottage in the term prior to the lease with Mrs. Maples. So she had every obvious logical reason to think they would continue to maintain and do what they were supposed to do. It was in the request for admissions and admitted the property would have been suitable for vacation lodging in this town. The maps, the plans that are of record there in the court, I think it had a 20-foot bathroom in it. Lots of possibilities for vacation lodging and what people like in the lodging. In November 2016, we had what's known as the Gatlinburg wildfires, tremendous fires all over town. Mainly the main street was completely saved. This home, half a block from the main street, burned to the ground. Ms. Maples, at the time of the fire, was already unable to handle her business affairs. She died in July following the fire in November at the age of 96. Her daughter had really no knowledge of the status of insurance. She knew that her mother had no insurance on the property. She was unable to locate any lease. She went to Park Grill on about 3 occasions and asked for a copy of the lease, and never managed to get a copy, despite the fact that the residents and one of the restaurants, they're next door neighbors. About almost a year after Ms. Maples died, the daughter's caregiver found a copy of the lease, brought it to this attorney for interpretation. We discovered that the lease did in fact require the tenant to maintain insurance on the property. That time, a demand letter was sent to the tenant to use that money for repairing the premises or turn the money over to the landlord. They refused, claiming they did maintain insurance, but they were not turning it over to the landlord. A few months later, the 10-year term of the lease ended, and they left the landlord with nothing but a scorched earth.
Excuse me for interrupting, counsel. I assume that it's undisputed that the repairs could not be made within 10 days following the fire damage or fire loss.
Your Honor, I think it's undisputed that most any repair in this town could not be made within 10 days. Using the insurance proceeds, that would involve getting a city building permit as well as processing an insurance claim. So, it's to be responsive, I apologize. It certainly could not have been rebuilt in 10 days.
And the lease did not otherwise require the lessee to rebuild the structure in the event of a total fire loss, as was in this case, correct?
It was not addressed. The lease itself was just a few pages long, very simple lease for a commercial lease.
Was that beneficiary listed on the insurance as to what those funds, the insurance funds, what would they be for? Was that beneficiary required?
No, only required that the tenant maintain fire and casualty insurance on the premises.
There was no indication, no statement as to what the purpose of that, of those insurance funds would be available for.
The lease did not state what the funds would be used for.
Okay, thank you.
Excuse me for interrupting again. In paragraph 8, did not the lease indicate that the insurance proceeds would be used in the event that the repairs could be made within 10 days?
That's what the entire case was decided upon. Yes, sir.
I was just referring to the provision in section 8 indicating, I'll just read it, in the event the premises are damaged by fire or other insurable loss, and the premises can be reasonably repaired within 10 working days, lessee shall undertake to make the repairs using the proceeds of the insurance policy.
Yes.
That's
Okay,
would,
that's the
would that
that's the
not
only
be,
exclusion. Okay, that's the only requirement, the 10 days repair.
It is. It's the only thing mentioned, Your Honor, but of course, we don't think that limited or it would have made any sense at all. What could you do in 10 days? Replace an air conditioner or a leaking roof?
Well, but you'll agree with me, Mr. Parton, though, that, you know, these parties drafted this contract and we can't rewrite it for them, and we can't include a provision that says what you do with the proceeds when it can't be repaired in 10 days if the parties didn't put it in there. Can we?
I believe you can, Your Honor. I think we have over 100 years of precedent where this state has ruled that if a lease requires either party to maintain insurance, that fire and casualty insurance, that the proceeds of that insurance are to be used to repair and replace the building.
Okay. Okay. Anything further, Councilor?
Sure. When attorneys are drafting leases, I know we often do including but not limited to on there. It's so easy to say something like insurance, or I'll use another example, doing the repairs to the building. And then if you go on and specifically state that the tenant is obligated to clean out all pipes prior to turning it over at the end of the lease term, I don't think that statement of the second should completely annihilate the original understanding that the tenant would make all repairs to the premises. It's just a more specific use.
Okay.
And
Thank you, sir. You have time for your rebuttal.
okay, thanks.
Let's move on to the appellee.
Good morning. May it please the court, Tyler Husky here for the appellee, Park Grill. And we do request that the Chancery Court's opinion here be affirmed. As Mr. Parton has mentioned, this was a short lease, but it was simple and it was straightforward as to what it said. It's easy to understand. The trial court found there were no disputed issues of material fact and that there was no doubt about what the lease said. There are three important provisions in this lease that will govern the outcome of this matter. The first is Section 5, and I think you all have already referenced that section. That section states in simple terms that the lessee shall have and maintain a fire insurance policy on these leased premises. That section does not provide that the fire insurance will be used for any damage to the leased premises, will be used to rebuild the leased premises, will be used for any purpose whatsoever. It just says that the lessee will have and maintain a fire and insurance policy on these leased premises. And goes on to point out that.
So who will be the beneficiary under the fire insurance policy?
Here, there is no beneficiary, so you have to go to Section 8 of the lease to find out what those are for. As you know, in Tennessee, typically the person who buys the insurance policy is the beneficiary unless something is by contract changes that. And here there was nothing in the contract that changed that. The beneficiary here would be, well, the only use of these policy proceeds would be if the property was damaged to the extent that could be reasonably be repaired within 10 working days, period. That's it. And in conjunction with that, Your Honor, it's important to recognize that Section 7 of the lease is entitled Maintenance. And it is pretty comprehensive in what the tenant is supposed to do as far as maintaining these premises. It states that the tenant will maintain the roof of the building, the outside of the building, the interior of the building. But there are no words in that section that the tenant would replace, rebuild, re-erect, nothing. Just a plain obligation for repair and maintain, nothing as to replace or rebuild in that section.
Is there a requirement as to how much insurance that will be provided, is to be provided by the fire insurance coverage?
Your Honor, there was no requirement for any amount. There was no requirement that the landlord be named as an insured. There was no requirement that the policy proceeds be used to replace or rebuild. There is no requirement in the lease that the policy proceeds would be assigned to the landlord. It was just a flat, simple requirement that the lessee would have and maintain a fire and casualty insurance policy on these leased premises.
Okay.
And I assume that under this lease, the lessee, the tenant, was the named insured and
Yes, Your Honor.
received the insurance proceeds following the fire loss.
Well, an entity, I think, named Stakes Sophisticated, who kind of manages this company, was the named insured for the purpose of for efficiency.
Would that be material to any of the issues in this case?
No, Your Honor.
All right, thank you.
It was maintained for the lessee's benefit. And so you must look over then to Section 8 of the lease after you've looked at Section 5, which states that the lessee is obligated to have and maintain a fire and insurance policy. And then consider the fact that the lease required only repair and maintenance obligations on the part of the lessee. And then the next provision that is relevant to this is Section 8, and it is entitled Fire Loss. Okay, this is going to tell you what happens in the event of a fire. And it specifically states, in the event these premises are damaged by fire or other insurable loss, and the premises can be reasonably repaired within 10 working days, lessee shall undertake to make these repairs using the proceeds of the fire insurance policy. It continues to afford either party in the event the premises cannot be reasonably repaired in 10 working days, it allows either party to terminate the lease. And here that was not done. Neither party terminated the lease. And contrary to what Mr. Parton said, I mean, the lessee did go in and remove all of the debris and tried to restore the premises to the best it could without rebuilding it, because there was no obligation. And I don't believe it's in the record anywhere that about what you can do or cannot do in 10 days in Gatlinburg. But in any event, the proceeds were only to be used in the event that they could be used to repair the building within 10 working days. And that's it. That was the only reference to the use of the proceeds whatsoever. And that makes sense in light of the tenant's obligations to repair. So as Judge Davis has noted, we enforce the contracts here in Tennessee in accordance with their terms. You look at the contract from the beginning to the end, when there are general and special provisions of special control over the general. Courts will not rewrite the contracts for the parties and will enforce them even if the terms appear harsh in absence of fraud or mistake, and neither of those were alleged here. So as the chancellor found, the lease was unambiguous as to the issues before the court, and that simply the lessee was required to maintain a fire and insurance policy, which it did, and that those policy proceeds would only be used for repairs that could be made in 10 working days. Now, this case is generally going to be governed by Section 667102D of the Tennessee Code. That section, of course, the plaintiff would like to take this case outside the coverage of that section, but here it most certainly applies. That statute provides that a promise by a lessee to keep and return the premises in good repair will not require the tenant, the lessee, to erect or pay for destroyed buildings that are destroyed as a result of a fire, unless they've specifically stipulated to do so in writing. Here, as we've noticed and mentioned several times, there was no express obligation of the tenant to restore these premises or to rebuild the premises or to pay for the restoration of these buildings. So that statute protects the tenant in this situation and provides that it has no obligation to rebuild. And if it has no obligation to rebuild, the insurance proceeds would not be applied to rebuild these premises. Again, the effect of the insurance was to fund the specific provision in the lease that provides that if the building can be repaired in 10 days, the tenant was required to use those proceeds to repair and for nothing further. There's no other requirement related to the use of the proceeds in the event of the premises were destroyed, and not even an implication. Now, plaintiff has stated a few times that 100 years of law and that there's this general requirement that anytime you have and you're required to maintain insurance as a tenant, that you're required to rebuild the building. I have not seen those cases. There is an EVCO case where the landlord was required to have insurance and the building was destroyed. And the court found that the landlord was in fact required to rebuild, even with only a duty to perform major repairs and maintain insurance. But that case specifically applies to a landlord. Section 66.7.102 does not apply to a landlord. And finally, the insurance required in that lease was for any damage to the lease premises. Here we do not have that broad requirement. But in any event, just remember, EVCO only applies to the landlord, and the statute 66.7.102 applies to the tenant and does not apply to the landlord. The tenant also references, the landlord also references the St. Paul case. The St. Paul case had a specific requirement to rebuild or replace the premises following their destruction. The tenant had that duty. The court even italicized the duty. You will repair, and then italicized the word replace the building. And the tenant did have an obligation to maintain insurance. But you got to remember, it was very important that that insurance was to be used to replace the building. And again, the court italicized that, added emphasis to that a couple of times throughout that case. The plaintiff also relies on a Hayes case that was cited, and that goes back to, it is an 1800s case. The plaintiff says that Hayes also requires this tenant to rebuild the building. Well, in Hayes, again, the lease specifically required the tenant to rebuild the building, which is not present in this case at all. Remember, Park Grill just has a obligation to repair and maintain, no obligation at all to rebuild. There was an obligation of the tenant to rebuild in St. Paul and an obligation of the tenant to rebuild in Hayes. The only other case is the Johnson case, which was before this court a while ago, and it came about as a result of the Gatlinburg wildfires. That case, there was no obligation of the tenant to repair or maintain, and there was also no obligation to maintain insurance. The landlord in that case did want an assignment of the proceeds, though, because the tenant had gone out and insured the premises on its own. This court found very specifically that the statute 66.7.102 did not require the tenant here in this case to rebuild. So if it did not have to rebuild, the statute removed any obligation to rebuild unless the party specifically contracted otherwise. So the statute, the court found, applied and protected the tenant and allowed the tenant to keep and retain the policy proceeds. They were not assigned to the landlord. The landlord did not recover them because, again, the court determined the statute controlled and removed any obligation to rebuild because the tenant did not specifically stipulate in the lease that it would rebuild. The tenant says there's some or insure language in Johnson, but that language in Johnson, the court said the court will not require the tenant to rebuild unless it is specifically stated or unless the tenant has insured or was required to insure against the destruction of the motel. And in this case, as you know, there was no requirement to insure against the destruction of the house. So, Your Honor, the court, the tenant here respectfully requests that the trial court's opinion be affirmed. Thank you.
Thank you, sir. The rebuttal.
Yes, sir. Your Honor, first and foremost, interpretation of a lease or a contract, you look to the intention of the parties. In the present case, both of these parties knew what that language meant. Park Grill went out and purchased a fire and casualty insurance policy. Ms. Maples did not. She relied upon Park Grill to carry the insurance on the building. As for the Johnson case, in the Johnson case, the tenant did exercise the statutory rights, and it isn't just this attorney who says that you have to exercise those rights in order for those to be binding on the parties. The EVCO case clearly says, Supreme Court of Tennessee case 1986, I believe, states that the statute is not mandatory, it's not compulsory. It's a right that the tenant, an option the tenant has to leave the property and not make any repairs whatsoever. In this case, it's undisputed that the tenant did not exercise his statutory right to terminate the lease. He stayed there until the end of the term. The other cases, the EVCO and St. Paul case, Your Honor, EVCO involved the landlord, but St. Paul then seemed to address the same issues in the reverse, where the tenant was required to maintain the insurance and held that that made the tenant responsible for rebuilding. And later Tennessee cases have gone with the Sutton approach with regard to subrogation interest between the parties. And I think most of the litigation in this state during the past several years has involved situations where landlord or the tenant sued the insurance company, basically sued the other party for subrogation. And Tennessee has followed the Sutton approach that insurance maintained under the contract is to be deemed to be available for both parties as co-insureds. It's there for the purpose of rebuilding the building. EVCO, the ruling in that case clearly supports the opposite position. It was so held in the St. Paul Lyons versus Bishop Gates case. That case did not involve just a requirement to rebuild. The Court of Appeals in that case held that that was irrelevant because both parties had determined not to rebuild. And the case was decided purely on the lease requiring insurance on the part of the tenant. And that court held that the money was intended to be used to rebuild the structure. We believe that's exactly what the intent was in this case. Otherwise, Ms. Maples would have gone out and purchased her own insurance policy to cover those premises. Otherwise, she would have charged much more rent for this home if she wasn't assuming that this tenant was going to assume the responsibilities of maintaining the insurance coverage, paying the taxes, and doing the maintenance on this property. Thank you.
Thank you, sir. Gentlemen, thank you both for your argument. We would consider this case. This case has now been submitted to the panel, and the panel will issue an opinion on this case in a due course of time. Thank you both. The attorneys may be excused.
Thank you.
This honorable court is in recess until 11:30 a.m.
Thank you, Ms. Angie.